talking about entrepreneurship, I would like to talk about the legal foundation, so the legal aspects of being an entrepreneur. So the first issue are issue related to ethics, business ethics when you're an entrepreneur. So business ethics is thinking about the long-term view of what all the things you're going to do, the impact it's going to have on your reputation and on the image of your brand, the way you can deal with your employees, the way you're going to deal with customers in order to build some loyalty with your customers. You also want to protect yourself and you want to avoid being fined, and you want to be able to have this great reputation and attract investors. One thing that comes next is, should I have an attorney? And yes, you should have an attorney as early as possible, because this attorney is going to help you build the right ethical part of your business in making networking and making contracts and partnership and building this relationship, making sure that you are not putting yourself into some position of liability from the beginning. It's important as well that they know what you're trying to achieve and understand the flow of your business. So to be a successful business person is you have to also do things the right way, so things don't come to get you in trouble later on. The first thing is you will probably have some partnership that are going to develop, and at the time of this partnership you want to make sure that you write down what is this partnership. So you're doing it by yourself, it's not as complicated, but you're doing it with someone else. You want to write something that is as clear as possible and doesn't mislead people. This agreement is going to talk about the issues related to how much money is everybody bringing, what is the percentage of ownership of the various people, what you're getting for what you brought to the table. And so it's also talking about how much money will be paid to the owners. So you could have a larger ownership and a smaller compensation. You could also talk about the fact that you not bringing just money, but you're bringing some kind of equity, which might be an equity based on maybe a trademark that you're bringing, or maybe some already some designs, some already existing, maybe unfinished, maybe finished products. Maybe you will be working and you won't be making some money, and that also is paid to you as you investing your sweat equity. And also it will discuss maybe the exit strategy for the individuals and how long is it planned for those owners to remain in this relationship. So it could be written that there's no date, it's till the end of the sale of the business, but there could be a situation where someone has an assignment within a certain time period. The founder agreement also needs to explain what is the nature of the business. So what is this business going to do? What would be the status and role of the individuals that are part of the foundation of this business? What would be the legal form of ownership? How you're going to divide the stocks, and what's the value of the stocks? Explain if there's some intellectual property and how you're going to divide the intellectual property, because there's the ownership of the business and then there's the ownership of the intellectual property. It's two different things. Maybe there's a capital that has been invested, and so how much, where is it, and who owns it? Maybe, it could be a situation where someone invests in the business, but this investment has to be returned. So there's two people, one invests sweat, the other one invests capital. Maybe you make an agreement that once there's profit, there's 90% that goes to the one that invested the financial capital and 10% that goes into the one that invested the sweat. So you have to disclose that. And that's the tricky, is the buyback clause. Is if one wants to keep the ownership, how do they keep the ownership? How do they buy the share of the other partner? So there's going to be an issue of time. Within a year, it's not the same as within 2 years. It's not the same if there is profit. There could be all kinds of many different decisions. There may be a time frame where things are being taken care of in a different way. Obviously, the more this is complicated, the more you're going to need a lawyer who is experienced in your industry. And the more this is complicated, the more expensive it's going to be to drafting this document. So there's the issue, which is it's so expensive to get lawyers that let's do nothing. That's the wrong way. And then it's so we are so complicated that we're going to make a very complicated document that's going to cost us essentially all the money we had to start the business. I'm saying this because I've seen it as well, where people have, $100,000, they think they have a lot of money, but they spend a lot of time with the lawyers, and here $35,000 goes into paying the lawyer for the drafting agreement. So now they only have 65,000 to start the business because they spend so much money with the lawyers. It happens a lot. Maybe it's better than that way than not doing anything, but it's important to sort of evolve maybe with the agreement and to sort of optimize your money for really the sake of building, but not ignoring the agreement. So it's a balance. Avoiding legal disputes is very important because that costs a lot of money, and you could have those 100,000 go in order to be fighting for some problems that you should have anticipated from the get-go. It's nice to trust people, but the idea is that you can't do business without trusting people, but at the same time, you don't want to 100% trust people, and you don't want to give them too long and too many chances as well. It's very important to try to put things in writing as often as possible. So that's why I say it's very important to use emails as much as possible, because with emails, you can put things more clear. I know people don't like to read long emails, and you should not be making too long emails, but sometimes it's very important to make long emails because that's the time to be very clear. Now let's talk about obtaining a business license. Depending on what you do, it's necessary maybe by your city to get a license, by the type of products that you're selling to get a license. So do that. Do not ignore the law, otherwise that's going to cost you a lot of money for having missed the opportunity to pay the fee, which was okay to start with. But then more complicated is choose the type of business organization that you're going to want. So there's four main. There's sole proprietorship, partnership, corporation, and LLC. So what are these? The sole proprietorship is the simplest, easiest way to get started with the business if you're by yourself. If you're not by yourself, it doesn't work. So if you're by yourself, you can start right now. It's a sole proprietor. It's what you need to realize is that you have to pay the taxes and you will get the profit directly to you. But the biggest problem of this one is that you are also responsible for the debts and the liabilities. So there's no protection. General or limited partnership is when you are more than one, so you can't do sole proprietorship. And in that situation, you can use the fact that your expenses and your profits are passed through. So you will pay the taxes through your personal income. However, this one has a big problem. There's no liability protection. The corporation, there's two types, the S Corp and the C Corp, are entities where you can have many partners, and it's essentially treated as if it was a person, the corporation, which means that they are responsible for the legal liability and also to pay the tax and make the profit. So the problem is, depending on if you use the S or the C Corp, you may be having some sort of double taxes where there's taxes of the corporation, and then you get a dividend, and then the dividend again is taxed the second time as an income. So there's pros and cons. There's a good protection. The problem with the corporation is that it's more expensive to form, and it's also much more expensive to maintain. However, it has some advantages if your company is becoming large and you also want to sell shares to people that you don't know, such as in the stock market. A limited liability company is not as good for the stock market, but it's great for limited partnership that would want to now get liability. The same thing as a limited partnership plus the liability. And then you can also get foreign investors. Sometimes in limited partnership, you cannot get foreign investors versus you can in limited liability company. However, LLC, I believe, are limited to a certain number of people. I forgot the number, but just like this on top of my head, maybe it's 30 or 40 people that you can have inside. And you may have more people investing, and so therefore you need to get the corporation. Once you get this kind of investments, once you get this kind of large organization, it's okay to get a corporation, even though it's more expensive. It's not a lot more expensive that if you have this kind of growth that you will be scared of it. and the maintenance is a lot more, but it's not like it's an incredible amount either. The issues when choosing legal business ownership is how much money do you have to start? Are you by yourself? Do you have other people investing? What you're doing, is it sort of dangerous, or how important it is to protect yourself and your liability? And then the taxes, how you want to pay the taxes, how you want to pay the losses and so forth. So there are how many investors you have. If you have investors, you are going to have to get a LLC or corporation. When you talk about the legal issues, you have to talk about copyrights, the ownership of the author, and it's important to protect yourself with these copyrights. But you have other type of protection, such as patents. So patent is more of an engineering perspective, where you have two types of patents. You have utility and design. The utility is it protects the function, the improvement of the function and how it works, versus the design, it protects the appearance, the look of the design. Trademark is the ownership of the brand, or some element of the brand that are very connected to the brand, maybe a sound, maybe a design style, or some kind of also graphic element of the brand that you want to protect, and that becomes the trademark. Doing the copyright and the trademark is something that you should have an attorney, but it's something that if you've done it a number of times, it's not as complicated as the patent. The patent is not so complicated if you're only trying to get the patent pending, but the patent pending doesn't give you protection. The patent pending is only here to protect you by showing that you are the first, or dating the time that you did it. So it gives you some kind of protection, and it doesn't last very long, the protection that you get from the patent pending, but it's a lot cheaper. If I had to give you a number, it's 10 times cheaper. $2,000 for the patent pending versus $20,000 for the patent as an overall ballpark number. So you may be doing something that you really need to have the patent, but you can't afford it. At least get the patent pending in view of being able to find some money down the road to get the patent, the full patent registration.